Good afternoon, everyone. Hi, my name is Angus Wilson. I'm an associate here at Semfure Tamarkin LLP out of the Vancouver office. I'm going to be on for the next half an hour to answer any employment law questions you have. My practice is mostly Vancouver-based, BC-based, but I'll do my best to answer questions as generally as I can. And my team here will help by providing any additional contact information. So let's talk about the news a little bit. Most recently, Scotiabank has joined a long list of employers that are terminating a bunch of employees at once. And everyone's a little uncertain about the tariffs, employers included, and that means that they are making big changes. And in some cases, that means big changes to their staffing. So Scotiabank announced that they were going to be laying off almost 2,500 people in and around the Toronto area. Really unfortunate. I mean, these are people's jobs, people's lives, but the important thing to know is that you have options. You're entitled to notice of this. You're entitled to severance, and we can help you get that. So just broad strokes, there's some employment standards that apply to federal employees, provincial employees. Broad strokes, things like Scotiabank are going to be federally regulated and have some specific stuff to do with that. If you're not a banking employee or something like that, you're more likely than not going to be a provincial employee. And wherever your employment is based, whether it's federal, provincial, or otherwise, there is a government organization out there that ensures that at least the minimum standards are being met. On the other hand, that is only the minimum. And it's important to talk to an employment lawyer every time you have any sort of questions about your employment. If your employment's being terminated, if you're being mistreated, give us a call. We have a link at help@employmentlawyer.ca, and we'll be able to answer more specific questions there as well. All right, I've got a comment from YouTube. So October 20th, I emailed my employer a doctor's note for 2 months sick leave, and they asked my doctor to complete 5 pages of a medical certificate. Okay, so what province are you in is, I suppose, my first question. In BC, there are some proposed changes to the Employment Standards Act that haven't yet come into force. So you're currently able to take up to, I believe it's 8 days, so 5 paid, 3 unpaid, before it becomes no longer an ESA and employment standards thing. Then it gets more into the human rights component. Why are you requesting the human rights? Sorry, why are you requesting the sick leave? Perhaps it's more of a workers' compensation kind of issue. I don't have all the information I need for that. But to bring it back, for short periods of sick leave, they shouldn't be asking for much information. If it's longer and it starts to trigger an employer's obligation to look into whether or not there are human rights things at play, whether there's an injury or illness that's factoring in, they can request very limited information. And you'll want to have that 5-page medical certificate reviewed. They're typically not able to ask for what your diagnosis is. They can ask for limited information about how long it's expected to persist and things like that. But the most surefire way is to have one of our lawyers look at it and give you a bit more specific information on how that applies to your circumstances. I've got a question from Alex on Reddit. My employer changed my job title and pay without asking. Can they legally do that? No, they can't, is the general answer. So when you started employment with your employer, it was some very specific terms that you've agreed to. Maybe it's salary, certain amount of vacation, job title, things like that. And if they've reduced your salary by a significant amount, or if you're hourly and they've cut your hours, so you're earning, say 15, 20% less than you did before, that can be a constructive dismissal of your employment. So that means they haven't given you a termination letter, but they're trying to introduce new terms to your employment that you didn't agree to. And your options at this point are basically to accept it, move on, keep on working under those new terms, at which point they become the new terms of your employment. Or you talk to us about how to deal with that as a constructive dismissal. Constructive dismissals are, they're tricky. So I'd certainly recommend you contact us at help@employmentlawyer.ca, which is going to be able to set you up with one of our employment lawyers. There we are, link in the bottom. Because yeah, that sounds like a situation that we should definitely discuss in greater depth. The job title itself can sometimes amount to a constructive dismissal as well. If it's a demotion, if there's actual sort of changes to your job description, but certainly worth a conversation. I've got a question from Devin on Facebook. Can my employer refuse to let me work from home even though my doctor recommended it as a reasonable accommodation? The very lawyerly answer, Devin, is it depends. If it's a position that can be done from home, then more likely than not, you should sort of keep that conversation ongoing. The thing with accommodation is it is a more of a conversation than one side saying exactly what it is. It depends what you've been doing up until this point, why that's being requested, things like that. But generally speaking, an employer has an obligation to accommodate disabilities up to the point of undue hardship. So if you're in a role that can be performed by home, performed from home rather, and you know, the only concerns are culture, or we want people in office so we can manage them better, there's a good chance they need to do better than that. And if you contact our link down below, we can set up a consultation to discuss specifically what's required in your circumstances and how to navigate this. All right, I've got a comment on YouTube. My boss always makes racist jokes. Is this allowed? People usually just brush it off because he's our boss. So what can we do? Yikes. This is something that we encounter from time to time. Most people know better. Some people don't. The thing that always strikes me is just like, if these people were employees saying the same things they say as employers, they would have been fired a while ago. But when you're on top, you don't have the same accountability sometimes, it seems. But you can, you know, within the realm of your employment, do a few things. First off, if you have an HR department, it's probably worth having a conversation with them. I know the old adage, HR works for the employer, but what they do is specifically work for the employer to minimize liability and risk. And if that employer, if your boss is saying things that are going to end up in landing you in hot water or them in hot water, HR will have to look into that and formalizing that complaint and letting them know that this is not okay through the proper channels. That's always an option. They're prohibited from taking any negative steps against you on that regard. If they're directed at you or directed at any of your coworkers, that could be the basis for a human rights complaint. Could be a constructive dismissal, as I was mentioning before, where you can treat your employment as having been terminated if it's directed at you. And that, again, is something that we can talk about in a bit longer of a confidential conversation, if you'd like. Once again, help@employmentlawyer.ca. Okay. I've got a question from Priya on Facebook. I signed a non-compete agreement years ago. Is this still enforceable if I change industries? Really, really interesting area of the law right now, for an employment law nerd like myself anyways. But Priya, good question. So if you're in Ontario, Ontario courts are refusing to enforce non-compete agreements. Non-solicitation is something that they can still look at, and again, that's something for a longer conversation with regard to the specific non-compete that you're talking about. But basically, non-competes need to be limited in the geographic scope that they apply to. So if it says the Lower Mainland, arguably that's ambiguous. But if we're talking about something that says you can't do this same industry in Surrey, well, that's going to be a geographic limitation that's probably going to be upheld by the courts. The next is going to be time. If it's 2 or more years, you're looking at a really long period of time where you're not able, because of this agreement, to do what you've been doing to earn an income. And courts don't like that very much. If there's no time limit on it, court's not going to uphold that. What I will say, though, with these kinds of non-compete agreements, just because they're probably going to be found unenforceable doesn't necessarily mean that an employer can't enforce them. It still does take time and money to defend against this kind of claim. Definitely, if it seems like they're going to make an issue of it, or you want a little more certainty than I can provide over a quick comment here, contact us at the link down below. We'll be happy to set up a consultation and give you a top to bottom assessment of that non-compete. Generally speaking, different industry, you're probably not competing with them in the first place, but never hurts to check. Okay. Ken O'Keefe, I do have that second comment. So regarding the medical certificate, reasons for, okay, so they're asking questions about reasons for medical leave, what sort of follow-ups. Yeah, Ken, my sort of initial first blush is that they're asking for way too much information. You're not asking for an unreasonable amount of time. You're saying essentially 2 months pending reassessment. And if you're unable to work, you're unable to work. Your doctor's opinion is the law as far as we're all concerned. So yeah, this seems like a situation that we're going to need to have a little bit longer of a conversation of, just to cover off everything. So please contact us down below at employmentlawyer.ca or help@employmentlawyer.ca, and we'll be able to set you up with a confidential, longer conversation on this. Okay, Zoe with a privacy-related question from YouTube. All right. I work remotely and I got written up for quote unquote not typing enough. They monitor our keystrokes and mouse movement. Is that considered invasive? This is a really sticky question. A lot of different things will come into play. Generally speaking, even if you work from home, they're allowed to do certain things to manage and make sure that you're actually doing the work that they paid you for. But this is really starting to get into the line of, is this unreasonable? I'd say that if you're working on a company laptop and it's not something that you use for your regular everyday life, you're probably into the realm of something that is unfortunately probably going to be okay in the eyes of the law. It's invasive. It's kind of gross, a little excessive, but it's not sort of to the degree that I think it would necessarily do you much good to push back on. On the other hand, if you're dealing with an employer that's asking you to put this software on a personal computer because they didn't pay you, they didn't provide a laptop or something like that, that's kind of where it makes sense to get your employer to actually provide a laptop. They shouldn't be putting this kind of spyware on something that you're using on a personal basis as well. But yeah, broadly speaking, even if you work from home, there are certain things that an employer can do to ensure that you're essentially meeting metrics. But if there's more if there's more questions arising from that, or you'd like us to have a closer look, please contact us, and we'll be happy to set up a longer conversation. Okay, from Artie MG23 on YouTube. My boss wants to put me on a layoff and is asking everyone to sign off on this. They said if we sign, they'll provide us with benefits coverage during the layoff. Should we sign? Is this allowed? So, Artie, the initial questions that I have are: have you ever been laid off before? Does your employment agreement, if any, have a provision that says that they're allowed to lay you off? And the third question is, are you in an industry that has frequent layoffs? If you're working in construction, for example, or forestry, those are industries that do have sort of a seasonal up and down. When we see these kinds of layoff letters, sometimes it is just truly a layoff where they say you're off for 10 weeks and then you're back after that. If they're asking you to actually sign off on something, though, and providing something in exchange for signing off on it, I would be really concerned that they're trying to put extra terms in there, selling it as a layoff, but not actually telling you exactly what's in that document. So should we sign? I wouldn't do it without talking to a lawyer. That's my my initial advice. Is this allowed? If you don't have any terms of your employment, if it's never happened before, generally speaking, they're not allowed to just lay you off unilaterally. That can be a constructive dismissal, which allows us to pursue your employer for full severance if they don't back down, or even if they do. Contact us at the link below. We'll be able to set you up with a consultation and give you some more specific information on that. Because yeah, if you've never been laid off before, well worth a conversation on that. Okay. I've got a question from YouTube from Emma. I reported unsafe working conditions and now I'm being scheduled for fewer hours. Is this considered retaliation? Probably. Yeah. So let's talk about what you can do about it. WorkSafe BC is the place to go for British Columbia. Every single province is going to have some sort of a workers' compensation scheme or workplace health and safety scheme. In BC, it's all covered off by WorkSafe BC. They have a specific team that deals with something called prohibited actions. A prohibited action complaint is what you'd file in these circumstances, because it seems like there's a direct link between you making a complaint about unsafe working conditions and now they're scheduling you for fewer shifts. So they're not allowed to do that. They're not allowed to mistreat you in any way because of a complaint that you made relating to workplace health and safety. If you've got original copies of the email that you sent to make the complaint, keep a record of that. If you've got a recollection of a conversation that happened, but you don't have any actual documents, I'd recommend that you take some documents, or rather take some notes right now, send them to yourself in an email and say, here's the conversation, here's what was discussed, and get in touch with us as well as WorkSafe BC to talk about how to file a prohibited action complaint. It's really easy. It's online. You can do it yourself, or you can contact us for some assistance with that. But no, the short answer, coming back to it, they're not allowed to do that. That is retaliation. And most importantly, that is what the law considers a prohibited action. All right. So I've got one from Stephen on YouTube. My manager has been contacting me and my coworkers after hours and said that it is expected that we check our email. Can they require this, but not pay us for this time? We're not considered an essential service. All right. So it really depends on the circumstances. There are going to be certain kinds of jobs, if they're managerial jobs, for example, where you're sort of expected to be available to answer questions. You may just have to answer those emails. But if we're talking about a situation where you're not in a managerial role and you're being expected to perform work, and we're not just talking about answer a quick email, but actually perform work, that may be a question of whether you're actually being compensated for all hours worked. And you should look into specifically what your contract says on that, and contact us for an opinion on that. Basically, you need to be paid for all hours worked, and they can't just unilaterally say you're working for free for us. You should also have a policy surrounding the right to unplug, the right to disconnect. And if you're expected to be answering emails at 10 o'clock at night, over the weekend, things like that, that can be a problem. So there's going to be some more information at employmentlawyer.ca, or if that's not covered specifically, happy to set up a conversation. Okay, heading into about the last 8 minutes, so I will just let you guys know that we are hosting another one of these sessions tomorrow with Lior Sanfiru at 1 p.m. Eastern time. So I believe that's 10 o'clock for us folks out here on the coast. I've got a YouTube comment from Mohammed Talla about frustration of contract. So frustration of contract, it is a little bit different from just your regular termination of employment. A termination or a resignation, that's one party saying, I'm not going to be continuing the contract. If it's an employee saying it, it's a resignation. If the employer says that, it's a termination. Frustration of contract is something a bit different, where it's essentially a determination as to whether the contract can still be performed. So we'll often see this come up in situations where there's a disability that's extended past 2, 3, or more years, where it's clear that the employee may not be coming back to work. That's a kind of situation where there's a frustration of contract. Employers sometimes will say it for circumstances like the business burned down and we're not planning on reopening. Whenever you see frustration of contract, it's a situation where an employer is trying to get out of paying severance. You may still be entitled to severance even if they've claimed it's a frustration. So ultimately, if you're looking at a situation where your employer's claimed a frustration of contract, get in touch with us below, help@employmentlawyer.ca. And we'll be in touch to schedule a consultation. Okay. I've got time for probably 2 more questions here. So if anyone's hanging on to have a question answered, I'm happy to do so. And once again, Lior Sanfiru is on tomorrow at 1 p.m. Eastern. All right. So I've got Darren Saul saying, if I make a complaint to my employer about bullying and harassment, can they put me on a leave of absence while they investigate? Darren, that's a fine question. No, they can't. If anything, they should be putting the person that you're complaining on about a leave of absence if it looks like a situation where there's still a risk of ongoing bullying and harassment. But at the very minimum, they need to do an investigation into that complaint It needs to be fair and impartial. Oftentimes that looks like them bringing in a third party, maybe a lawyer, maybe just a trained workplace investigator. But generally speaking, the person who makes the complaint is never the one that should be punished for it. And that includes being placed on a leave of absence, whether paid or unpaid. Okay, so I have reached the end of my list of questions here, but if anyone else is hanging on with one more question, I'm happy to answer. Otherwise, I'm happy to talk about Scotiabank a little bit more. Oh, here we go. Got one from Steven on YouTube. Can my employer stop me from taking a second job or force me to quit another job if I need to make enough income to support my family? Great question, Stephen. There's no inherent right for an employer to say you can't take a second job. There are certain employment agreements and terms in employment agreements that do basically say we're paying you enough to have you as this sort of sole employment relationship. Other situations. You're welcome, Darren. Talk to you soon. Back to Stephen's question here. So generally speaking, they're not allowed to just prohibit you from taking another job. Where that changes is if that other job is starting to interfere with your job duties at the other role. You can't take a job that has you paid for the same hours. So if you're working 9 to 5 and you're looking at taking a job over the weekend, that's a very different story than having 2 remote jobs where you're being paid from 9 to 5 for each job. You've got a couple of laptops open. That's where it really becomes an issue. Generally speaking, yeah, they're not going to be able to just prohibit you outright from taking a second job unless there's something in your contract. And we'll be able to review this for you in a longer, completely confidential consultation. You can contact us at help@employmentlawyer.ca. A follow-up from Ken O'Keefe, and this will be the last question for today. Once again, Lior Samfiru is on tomorrow at 1 p.m. Eastern. So Ken, I understand that to mean the employer withdrew the medical certificate request that they had asked for 1 week ago. I mean, quite frankly, it sounds like they realized they were asking for too much information. They might have talked to an employment lawyer that set them straight. But if they've withdrawn it at this point, you've got the doctor's note. They shouldn't take any steps against you with regard to your employment. And if anything changes, if they indicate to you that your position's not going to be around when you come back, try to demote you. Trust me, we've seen it all. Do get in touch with us. We'll be happy to set you up with a confidential consultation. Check out more at employmentlawyer.ca or contact us at help@employmentlawyer.ca, and we'll be able to give you a little bit more specific information. All right, that is all for today. Thank you all for your questions. Come back tomorrow if you still have some more. Lior Samfiru, the top dog at Samfiru Tamarkin for the employment side, is back on tomorrow at 1 p.m. Eastern, 10 a.m. Pacific Standard Time. Okay, thank you, everybody. Have a great rest of your day.